I'm coming to you live from my kitchen table. First time I've tried this, so hopefully all of the tech is going to go according to plan. This is the fourth in our daily action calls for the Greensboro Chamber of Commerce. We really appreciate those who have been participating with us. I know we have some repeat folks on the line with us. We appreciate y'all. This is what Chambers of Commerce do. We connect people with people. We connect businesses with businesses. We connect problems with solutions. We should all be at the Greensboro Coliseum right about now watching some basketball if everything had gone according to plan. Obviously it didn't, and we're faced with a bit of a new normal. And so as we've been going through this week talking about what that means for small business, for our members, for the community at large, we've been bringing experts in, and today we're bringing an expert in employment law to kind of help us go through some of the changes. I mean, things are changing rapidly. We all realize this is a very fluid situation. Alex probably has some answers, but may tell us that things are still changing as we speak. So our speaker today, or our guest today, is Alex Maultsby. He's a partner at Fox Rothschild, LLP, attorneys at law. He is an expert in employment law and is a graduate of the University of North Carolina School of Law, as well as Davidson College, where he got his bachelor's degree. He's been active in a number of civic and community activities, including the chair of the Board of Communities and Schools of Greater Greensboro. He's worked on the board of the Barnabas Network. He serves on the board of Goodwill Industries in Central Carolina and counsels several numerous nonprofit organizations, including ours. He served on numerous committees of the North Carolina Bar Association, including as a member of the Labor and Employment Section Council. Alex, thank you for being willing to join us today. We thank you very much for your time. And anything you wanted to add to that bio before we get started?
No, I'd like to delete some things from it, Frank.
Where are you coming to us from?
I am coming.
You have an office at home, or do you have a kitchen table like me?
I'm on the sofa.
Gotcha. Well, that works too. We're all learning.
We're all learning.
We're all learning how to do this.
So. I was at one point an expert in employment law, but that was like 2 weeks ago.
Well, you still are. You're going to be our expert for today. So
we'll do it.
Let's go ahead and get started. This week has felt like a month. Every day feels like a week. So after all of this week and last, what are you finding to be employers' biggest concerns in this new situation we find ourselves in?
Yeah, good question. The conversations I have flip-flop back and forth from the broad to the minute, but it really has been consistently employers looking out for the safety and well-being of their employees, number one, which is nice to see. What that means is changing rapidly, but other than, schools and churches, workplaces are where we interact with others the most, and schools are closed and churches are closed. And so, this is it. And there's been a lot of thinking about how do we set people up to work remotely and what special considerations might that involve. And then, lately, really that has morphed into evaluating not just how long can we let people work remotely and who can we let work remotely, but how long can we afford to keep people given the economic pressures. I think keeping our eyes on what our duties are if we do have to let people go, whether it's a layoff or putting people on a temporary leave, has particularly with this new law become the focus this week. And then evaluating this question of, can we put people on leave? Should we put people on leave, or do we need to actually terminate employment? There's a lot of language confusion from time to time on what a layoff means, how that relates to a furlough or a discharge. I'm going to try to be precise in our conversation today and not talk about layoff, because for some people it means or implies that we're sending people home for a little while and then bringing them back. And for others, it implies that my employment is over because I've been, quote, laid off. So I'm going to talk about furloughs, which are sort of a leave for a period of time with the hope and expectation of bringing somebody back, and then discharge on the other hand. And I think people are beginning to wrestle with that, which is not a comfortable place to be.
No, it's certainly not comfortable in any way, but I think we're learning that we're going to be uncomfortable in many, many ways for a while. So we've got to make our own comfort. I will say, as we go through, I'll pause here for just a second to let everybody know, you can, if you're on Zoom, you can take a look. There's a group chat portion of the screen there, that if you want to type in a question for Alex, we'd love for you to do that as we go through this, and we'll ask Alex those questions as we go through. If you don't have access to that and you want to send it to us via Twitter, you can follow the Greensboro Chamber on Facebook, on Instagram, on Twitter at GSO Chamber. And that's where, if you could tweet us a question for Alex, we'd be happy to get those in front of him too. Again, at GSO Chamber. And so you kind of alluded to it there, Alex, about the new law passed this week at the federal level, giving some leave rights, some new pay rights. What happened there regarding employees, and how is it affecting us now?
Yeah, good question. So the beginning of this new law was with the House of Representatives, and in the very beginning there was some thought that part of what this package would include would be some pay requirements if you did furlough employees, or some severance pay obligations if you did discharge them. That all relatively disappeared out of the statute, and so we're left with really two things that are going on there. One is paid sick leave, and one is a new and different opportunity to take FMLA, coupled with some compensation if you take that new and different type of FMLA. So let me just walk through those separately. They can overlap under some circumstances, but they really are two different things. So the sick leave law, or the paid sick leave law, applies to all employers who have less than 500 employees. And it says that if you, as an employee, are diagnosed with COVID-19, if you are quarantined out of a concern over whether you have COVID-19 or have been exposed to it, or if you are caring for someone who either has it or has been quarantined as a result of it, then you are entitled to 14 days worth of paid leave. So you're entitled to have the time off to either, deal with the fact that you're sick or to care for somebody who is, and you're entitled to be paid. There are some caps on that pay, and the caps depend on whether you are sick or whether you are caring for somebody else who is sick. If you're sick, the cap is $511 a day. Don't ask me where they came up with that one. If you are out because you are caring for somebody who is sick or someone who is quarantined, then the cap on the pay is $200 a day. So, there are lots of detailed questions about how does that apply to temporary employees, and, we could talk about that forever. But that's the general framework of the paid leave. If you need to be out because of something about you that relates to COVID-19, you've either got it or a doctor has said, well, we don't know, but you should be quarantined, then you get 2 weeks of paid leave for that. The 2 weeks of paid leave is on top of any other paid leave that your employer already provides. So we're telling clients, you may have a sick leave policy that provides for sick leave on a yearly basis, and an employee may have accumulated 30 days of it. But you should consider this to be 14 new days of paid leave on top of whatever else they've already gotten. That might be super conservative, but that's what we're telling people. The other piece is an FMLA expansion. And here's what happened there. And it's really narrow. And I think there's some confusion about this because there's been so much talk about new paid sick leave. But the new expansion under the FMLA applies if you are needed to provide care for a minor child whose school has closed or whose child care has, otherwise been taken away for virus-related reasons. In that case, you get 12 weeks of FMLA, just like anybody else who has ever needed FMLA leave. And while the first 2 weeks are unpaid, beginning with the third week and through the balance of your full entitlement to 12 weeks of FMLA leave, you're entitled to get 66% of your pay. Now, there are a lot of people who are not telling their employer that they need to be home because their child is out from school. They're just making it work. But once sort of this law gets out there for greater public consumption, I think we're going to see a lot of employees raise their hand and say, I need to be home to care for my child whose school closed. And most employers are going to have to pay those employees 66% of their pay beginning on the third week through the end of the 12th week, assuming that they haven't, sort of already otherwise used their FMLA during the course of the year. There is a provision that says you're going to be able to recoup what you pay here through offsets against Social Security taxes that you have to pay. And if you don't pay enough Social Security tax to wind up recouping enough, then you can file an application and tell the Treasury Department, and they'll send you a check to make up the difference. So it's a shift of that responsibility on a sort of temporary basis from the government to employers to kind of front that money. And, that's a cash flow issue. One of the things that we've seen is that employers have begun to do sort of an obvious calculation. I kind of referred to this in the beginning a little bit, which is, well, am I better or is my employee better if I just lay them off? There I go with layoff. If I just discharge them, I won't have to pay the 66% for weeks 3 through 12, but they'll be able to go get unemployment, which is frankly the same amount of money, and it'll just be cleaner that way. And so there's a lot of this back and forth going on. There are pros and cons both ways. You can't pick on people and let them go because they may invoke their leave rights. That would be retaliatory and against the law. But that's what people are wrestling with. That's a lot about that law, but I think it's important to recognize that there's really two big things. One is paid leave for people who are sick or looking after somebody who is sick, and there's an expanded FMLA for people who have to basically, in concept, be home for their kids because school's been closed.
I'm looking at some of these questions, Alex, on the chat right now. One of them is who pays out for the full FMLA? I think maybe you've answered that, but you may want to clarify since there's a question on that.
Yeah, the employer has to pay that, and you can tell the government you had to do it, and you can get your money back. It's complicated. It first comes out of Social Security taxes that you would otherwise pay, and then after that, you can file an application for reimbursement of the balance.
Another question, virus-related reasons. Is this an illness of the child or just the school was closed as a result of the pandemic?
If under the FMLA component, it is just because the school was closed. You can have a perfectly healthy child and still be entitled to the FMLA provision. Now, just to be clear, the FMLA provision does not kick in for the first 2 weeks of the leave. It entitles somebody to the leave, but it doesn't kick in from a pay perspective until the third week. The other piece of this new statute, which is the sick leave, could cover those first 2 weeks if you've got both a child home from school, which is basically all children, and you've got a sick child who either is infected with the virus or has been quarantined out of concern for infection.
Right. Or how about you?
Or yourself,
Or
right?
yourself, right?
Or yourself, for sure.
Right.
So yeah, you could layer, if somebody's been quarantined by the doctor, then, and they have a kid, like they could layer on the first 2 weeks, they get their full pay at the cap of $511 a day. And then after that runs out, they can get 66% of their pay because they are responsible for looking after a child whose school is closed. Now, everybody's first, well, that's not the right way to say it. There are plenty of questions about the veracity of representations that you get from your employees about all this. And the law does not speak at all to, what types of certifications you can require. The FMLA, so think the home from school piece, the FMLA has lots of certification rules, very detailed certification rules, and it's just not clear that they're going to apply here because all of them have to do with getting certifications from healthcare providers. And this law doesn't require you to go get a healthcare provider to say that you're needed at home because your kid's school is closed. So, there's going to be questions about, well, why can't your, spouse do this instead of you? And nobody knows how to unravel all that, frankly.
Yeah, and I think that's what the next question's getting at is, does this special FMLA still follow the same FMLA rules in terms of length of service requirements for FMLA eligibility, I guess?
Yeah, thanks for asking that. That is a slightly different question and a good one that I didn't clarify. So typically to be entitled to FMLA leave, you have to have worked for 12 months. They've compressed that, and this leave right applies to anyone who has worked for 30 days.
Okay.
Also, the FMLA only applies to employers who have 50 or more employees, and that has also been eliminated. So this FMLA leave related to the school closure applies now essentially to every employer with less than 500 employees, even those who have never been covered by the FMLA before because they have fewer than 50 employees.
So all of this is less than 500 employees.
Correct.
Everything that we're looking at is less than 500 employees at this point.
That is correct.
Okay.
And, there's been a lot of head scratching over why. I think some of it is the belief that large companies are already, by and large doing this. So they just made a judgment call at the policy level and cut it off at 500. It's definitely arbitrary.
Yeah. Well, and we've got another member who says, in addition, both allow subsequent U.S. Department of Labor regulations to exempt small businesses with fewer than 50 employees with the provision would jeopardize the viability of the business as a going concern. Do you have any thoughts on that?
It is in the it's in the statute. It is going to be something that I think people pursue if they don't provide this benefit and they get some enforcement action. That's going to be, a defense, or
right.
You just can't do it and you want to pursue that. I will say that what do I really know about what I'm about to say? So there you go. But it would be easy to file an application like that and quite credible to claim that this will undo me as a business. And I just don't think they're going to grant widespread exceptions.
Right. Gotcha. So far we've talked about the federal level. I know I've been seeing some things on the state level as well. Can you talk about how that layers in here as well?
Yes. So on the state level, really what has happened has come from the governor's office and not the legislature. And Governor Cooper has some ability to manage the Division of Employment Security, which is unemployment. And so what's happened there is that the unemployment benefits typically come after a 1 week waiting period. And the 1 week waiting period has been waived. So employees who suffer the type of employment loss that would entitle them to receive unemployment don't have to wait a week. The law also says that employers will not be charged for benefits that are paid to employees who were separated from employment because of the virus. So, what typically happens when somebody files for unemployment is that they go file a notice comes to the employer from the state that says, tell me why this person lost their job. Employers are going to want to say, and it could be that they're going to develop a form that puts a box there and makes this super easy, but employers are going to want to report back that the individual was separated from employment because of, closure or downsizing or issues related to COVID-19. Because at the end of the year, when all this is reconciled in the various ways it gets reconciled, employers are supposedly not going to be allocated responsibility for any benefits that were paid out for that reason. There's also, and this is a little bit down in the weeds of unemployment law, but surprisingly enough, one of the reasons that you can be denied unemployment is that you have a medical condition that prevents you from working. That has been eliminated with regard to the virus. So if somebody files for unemployment and says, I got the virus and I can't work anymore, that's not going to be a reason to disqualify them for benefits. So really the state level has just been a matter of trying to shore up unemployment benefits. There's state and there's local. And, one of the things that I don't think anybody's quite gotten their mind around is when you get a shelter in place order, which has happened, as I understand it, in Mecklenburg County. How does that relate to this concept of being quarantined under the Paid Leave Act? Is that the same as being quarantined? You've basically been told, don't leave your house. I think there are exceptions for going to work, et cetera. But as those continue to roll out and everything suggests it's going to get more and more restrictive in terms of social distancing, it just raises lots of interesting questions that nobody's addressed yet.
Alex, we're getting questions about, does this apply to employees on furlough? Maybe you could give kind of a just a brief synopsis of furlough. Those different definitions.
I understand that question, and I'll say this is a super good question, and I don't think there's an answer for it. And when I say this, I'm going to frame it as follows. We put somebody on furlough for a business downturn reason, and we tell them you are not needed for 4 weeks. They come back the next day. Well, let's take it a week out. They come back a week out and say, I've now been ordered quarantined by my doctor. If you had not put me on furlough, I would be entitled to paid leave because I qualify under this paid leave statute. The question is, are they in fact entitled now, even though they're already on leave on an unpaid basis? Have they suddenly sprung into a situation where they are now entitled to get money, even though they and all of their coworkers, let's say, are home unpaid? And that is not answered well in the statute. In fact, it's not answered at all in the statute. The statute says it is for people who are unable to work because of, and so is that person unable to work because of the quarantine? Maybe if you say work generally for anyone, the reason that they're unable to work for us, the employer, is not because they're sick, but because we've already told them they're unable to work because we don't have any work for them to do. The best advice is generally the most conservative advice. We've got a group that's actually looked at this within our firm and hashed it out amongst themselves. And while nobody's super confident, the best advice that we're giving is that you should pay those people who are already on leave, but sort of spring to life with a reason that they would get paid were they not on leave. You need to pay them as if they were not on leave. And this is incredibly difficult to manage. and incredibly difficult to plan for. The reason that you're putting them on furlough in the first place is because you can't afford to pay them. And then, you're getting, although nothing here should be construed as legal advice from an attorney to its client, right? But you're hearing from a lawyer, well, we may have to pay them anyway, even though they're on leave. And that's just a shortcoming in the drafting of the statute. Typically what happens is Congress passes a statute, and then the EEOC, or the Department of Labor, writes reams of regulations, and everybody complains about regulations and red tape. But the reason that happens is because the actual statutes written by Congress don't go into enough detail to answer these kinds of questions. And because this is so new, there's no regulatory interpretation from the EEOC or the Department of Labor yet. We may get that. They are working at hyperspeed to come up with it and provide some answers to these kinds of questions.
Great. This is an interesting question, one that I hadn't thought about. Can you end the FMLA the last day of the school year? Would you have to pay through the summer as well, right? If this is FMLA to take care of a school-age child, you would, the school year ends at some point, although I think there's some uncertainty about that as well. Maybe that's not something that's been contemplated quite yet.
Yeah, I mean, it's not. There was nothing specified in the statute, and I would back up, just one quick step and say the statute itself is all that we have to go on. So what you got is the statute, and then you got sort of, well, this seems like a reasonable way to understand these words, or this seems like what a judge would do if confronted with it, or this seems like what the Department of Labor would say if it ever got before them. I would say that, the language of the statute says unable due to the closure of a school due to an emergency declaration. So I think when schools sort of otherwise out for the summer, that this FMLA doesn't apply anymore. And here we are at a time of year when, 12 weeks out, that's going to fall in the middle.
Sorry, trying to get to my unmute button so that you all don't hear my dog in the background. Great question here. Unemployment first requires the employee to use their available PTO, paid time off first. Is available PTO what has been earned year to date or expected to earn for the calendar year? Do you have any advice on that?
Yeah, so that is exactly correct. PTO is not sort of statute based, and so what an employee has in terms of paid time off rights depends on how the employer has framed PTO at that workplace. So as an employer, you can have a policy that says, here's the PTO you earn. It is never paid out at the end of employment. If your employment ends and you've got it accrued, it's just forfeited. If that's what the policy is, then there's no, the unemployment piece is completely unaffected by it. You could have a policy that says you have the opportunity to earn, I'll make this a really simple example. You have the opportunity to earn 12 days of PTO this year. You will accrue them, 1 day a month. And here we are in, let's just call it the end of March. That person only has 3 days. That's all that will be factored in for purposes of unemployment. And that assumes that the employer doesn't have a use it or lose it policy. So if that person's employment ends at the end of March, then he or she is entitled to 3 days of PTO. That'll be factored into when unemployment starts. You could have a policy as an employer that says you get 12 days of PTO every year. If you're silent as to how it accrues, it's generally considered to all accrue on January 1. The employee hasn't used any of it prior to the end of March. That employee is going to have 12 days of PTO available, and unemployment's not going to start until after those 12 days. It's unclear whether, so let me say this, generally sick leave is not treated the same way for this purpose that we've been talking about unemployment if sick leave is its own bucket of leave, because you're not just entitled to be paid that at any point, you're entitled to take those days off without losing pay. So I don't think that there's anything about this new granting of paid sick leave that is going to cause unemployment benefits to be delayed, because I don't think anybody's entitled to just be paid that sick leave at the end of their employment if they didn't ever have to access it.
Gotcha. Here's a really specific one, and we can get. I think we can get wrapped around the axle sometimes with all of the different what ifs. But what about an employee on furlough collecting unemployment, becomes ill with COVID-19? How do you handle paid sick leave, or even a similar combination with the new FMLA? What's your thoughts on that?
Call your lawyer when it happens. Look, there's an argument that person is entitled to get the pay from us. If they get the pay from us, they've got to tell the unemployment commission. The unemployment commission is then going to, and by us, parenthetically, I mean the employer. If that happens, then the employee's got an obligation to tell the unemployment commission, hey, I'm getting this money from my employer, and that is going to minimize dollar for dollar what they would get in unemployment benefits. It's conceivable that an employee would have an incentive to do that because as current, and I can't tell you what it is, but currently there is a cap on the number of weeks that you can get unemployment. And so if you can stop the quote getting of unemployment benefits by kicking over to receiving replacement money from your employer, then there's I think like we've never been here before, but I think that would delay the running of your total allotment of unemployment benefits, essentially extending the time over which you can receive them. So I think all that could happen.
So you just mentioned call your attorney, and you said this in an email, so I'm not. You said give them my phone number liberally. I'll tell everyone that if they call me and say they're on this call, I will have a conversation with them without charge. You might regret that, yes, but your phone number is 336-378-5331, right?
That's right, and the offer holds because look, this stuff is flying fast. It's down in the weeds. You can't even imagine the questions until you encounter it. So there's no way on this call that we could cover, the waterfront. And so I'm happy to sort of extend the call, so to speak, that way.
Great. And I know that you may be taking their calls from your couch, but you'll take them nonetheless, right?
Yeah. And if I don't get back to you until tomorrow or Sunday, it's just because.
Understood. Well, Alex, I appreciate your time. It looks like we've exhausted all the questions. We're at 3:35, which is about the length of time we've been running these calls, just enough to answer some questions, give everybody the basics, but also give them some opportunity to find other resources. And so obviously you're one of those resources, and we'll make sure that everybody gets an opportunity to get a wrap up of this call. We send the email out to all of our members at the end of each one of these calls. So we'll send that out as well. And we also archive these calls as well on our website. So if you joined midstream, you feel like you missed something, you can always go back and listen to that call again.
Brent.
Yes, sir.
Brent, this is Gary McCants. I have a quick question before you close out.
Go ahead.
And you may have answered this already. I mean, obviously, with the demand that's going to be coming in for any kind of capital or credit needs, what's the turnaround time to get this stuff processed?
Gary, I'm not sure that we've got an expert on the phone that can answer that. We're talking about unemployment today. Yesterday was small business administration. So if you'll go back, that call is again archived on our website, as well as has information on that. There, the talk yesterday was about an 8-day application period, and then somewhere around 21 days for approval. But
even with the processing of unemployment, the process of that paperwork is kind of
I'm
taking a while to
sorry.
get that done.
I'm sorry. Let's talk about, and I don't know whether, Alex, you have that particular answer.
No, I mean, I don't know. It is, you're interacting with an overwhelmed government agency. That's like the best answer I can give you. Already on their website, they've got a banner across the top that says, "We are experiencing high call volume. The best way to fill out an application for unemployment is online." So that tells you already that they are jammed to the gills.
We're going to have to be patient. We're going to have to be patient through this. There's no doubt about that.
Thank you.
For the question, Gary. And if you can't find the answer, give me a ring. We'll find it.
Absolutely. Thanks.
Thank you. And we'll work to get an answer. Now, thanks again, Alex, for all of your work on this. I do want to say a couple of things. We're going to be talking about unemployment itself, the unemployment process itself on Monday, Gary and others on this call. So we'll have somebody from the North Carolina Works, from our local workforce development operation here in Guilford County, and hopefully somebody from the state. But if you've got some additional questions along those lines, we will be happy to do that. We'll be happy to answer those questions on Monday. We should have some experts on there on Monday's call. So again, thank you all for joining us. We'll be back with you again on Monday. 2 quick plugs before we leave this call. One is for the census. Make sure that you're filling out your census forms. It's very important for us for federal funding purposes, for representation purposes at a federal level. There are a lot of things that depend on the results of that census. So take some time while you've got it and fill out those census forms so that we can make sure we're getting what we so richly deserve and need here in Guilford County. So please do that for us. And second, I would say, hey, give blood. That's one thing you can do in this time of need. We're at the weekend at this point. If you need some food, please check out our list of restaurants that are still serving carry out and for carry out, curbside delivery and delivery to the home. Buy some gift cards if you can. I know there was a vicious rumor going around out there that we were going to be shelter in place in the state of North Carolina. The governor about an hour ago sent out a tweet that said that is not the case. So we could put that rumor to rest, at least for the weekend. So anyway, we made it through the week. Alex, again, thanks for your time. Thanks for being an expert for us on this. Thanks for giving out your phone number. Again, 336-378-5331. Everybody have a great weekend, and we'll talk again on Monday at 3 p.m. Thanks so much. Have a great weekend. Alex, thank you so much.
Yeah, thank you.
Bye now.